Yes, দেখি।
তোমাকে বলছো না কেন উল্টো পাল্টা বলছো, ওটা আমাকে হাতে ধরিয়ে দিয়েছো।
What is this? Can 1 of 2026?
Milord, can 1, Milord, is the stay, and can 2, Milord, is the.
Okay, those are all disposed.
Those are all disposed of. Milord, interim order passed, Milord, and the money deposited. It's only, Milord, in the district, Milord, the. Instead of Poschim Mednipur, Milord, it was Poschim Bod. আরে इसका brief দেন আপনি। হ্যাঁ শুধু মেমোটা দিলেই হয়ে যাবে। Can তো ঠিক আছে।
Yes, learned advocates for the parties are present. It is submitted by the learned advocates that in the memorandum of appeal cause title, instead of the
পশ্চিম মেদিনীপুর,
instead in memorandum of appeal in page 2,
page 2, Milord.
Instead of
Milord, the very first page, Milord, where the cause title is given at the top left, Milord, the district is written.
okay.
Not
in the memorandum appeal first page, in the cause title, instead of district Poschim Bardhaman, the same be rectified and corrected as Poschim Medinipur.
Lordship, Milord, the same correction be done in the back sheet also, because the back sheet
same rectification be effected in the back page of the memorandum of appeal.
Milord, can is pending. Is it necessary, Milord, if I put it to myself to correct the can also, Milord?
Necessary rectification be made in the interlocutory applications which are pending.
Extremely grateful to my Lord.
Any day subject to convene to your lordship.
The paper books are ready.
Paper books is ready.
Trial court records have come.
So I have all the certified copies.
So this matter can be settled.
Settled, bolo.
Okay, let it go. Learned advocates, upon hearing the learned advocates, this court is of the view that there is a chance of settlement in this matter. Let this matter go to the National Lok Adalat to be held in the month of September. Fix 18/9/2026 for report of the National Lok Adalat and further orders.
কালেকশন করে দাও, আমার সই দিয়ে করে দাও না, ভুলে যাবো। Grateful to your lordship.
Grateful.
আমি যদি করিয়ে দাও। Of insurance company. This is appearing for the first time, but I was paying for interim stay. I have made the statutory deposit of rupees 25,000. And may Milord, there are two applications. Milord, one is condonation, and Milord, and one is stay. Milord, stay is can 1, condonation is can 2.
So can 2 service is complete.
Service is complete. May I file my affidavit of service, Milord?
Yes, record an order. Learned advocates for the appellant is present. None appears for the respondents in spite of service of notice. The affidavit of service filed be kept with the record. The application for condonation of delay being can 2 of 2026 is taken up for hearing. Heard learned advocate for the appellant peruse the petition filed. Upon perusing the petition and upon hearing the learned advocate, this court finds that delay in preferring this appeal is explained. Stop. Thus, the prayer for condonation of delay is allowed. Can 2 of 2026 stands disposed. Stop. And the appeal is admitted. The application for stay, can 1 of 2026 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 22nd May 2025, read with order number 62 dated 19th September 2025, passed by learned additional district judge, second court, Shuri Birbhum, in MACC number 72 of 2018 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within, excluding statutory amount, within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. We register the appellant shall cause service of notice upon the respondents both personally through registered post as well as through the department by filling up necessary requisites.
This appeal is only confined to quantum. So, my lord, service of notice of appeal, my lord, upon respondent number 3, we dispensed with.
Okay, just upon respondent number 1, 2, and 1 and 2, 1 and 2, personally through registered post as well as through the department by filling up necessary requisites. Stop. The service of notice upon respondent number 3 is dispensed with. The trial court records be called for at the special messenger.
I've got the certified copy. Let them.
Anyway, the trial court records be called for.
I'm grateful to you.
And the paper books be prepared on arrival of the trial court records. Liberty to mention after 5 weeks.
Extremely grateful to my lord.
Lordship, I'm for the appellant, your lordship. I'm praying for not today.
Okay, not this week.
Lord, 89 is also, my lord, the appeal of insurance companies appearing for the first time. Lord, I have made the statutory deposit. I have also served, my lord. They have received, my lord, my affidavit of service, my lord, is there before your lordship. I was praying for interim stay.
Can 2.
My lord, can 2, my lord. Yes. My lord, can 1 is the condonation of delay
Okay,
application.
can 1.
Lordship.
Yes, learned advocate for the appellant is present. None appears for the respondents. You have served all the respondents.
My lord, yes.
In spite of service of notice, the affidavit of service file be kept with the record. The application for condonation of delay being Can 1 of 2026 is taken up for consideration. Hard learned advocate peruse the petition filed. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that the appellant has been able to show grounds for condonation, sufficient grounds for condonation of delay. Thus, delay in filing this appeal is condoned and the appeal is admitted. Stop. The application for stay Can 2 of 2026 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 23rd day of April 2025 passed by learned district judge Purulia in MSC case number 103 of 2019 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The registrar ota kore deben. The appellant shall cause service of notice upon the respondents both personally through registered post as well as through the department by filling up necessary forms and requisites. The trial court records
My lord, I've got the certified copy.
Okay, trial court normal we call for. The paper books be prepared on arrival of the trial court records. Liberty to mention after 5 weeks.
I'm obliged to my lord. My lord.
On 90, I am appearing for the respondent claimants.
After
Respondent claimant, my lord. I have received notice have been served, my lord.
item 90,
90, my lord, I am for the appellant insurance company. My lord, I have served.
both section 5 and
My lord, both section 5 and stay. My lord, Can 1 is, my lord, the condonation of delay application. My lord, may I file my affidavit of service?
vehicle owner has not received.
My lord, vehicle owner has not received. My lord, I want, my lord, the dispensation of service, my lord, because it is only on quantum.
Yes, record an order. Learned advocates for the appellant and learned advocate for respondent number 1 and 2 are present. Service of notice upon respondent number 3 is dispensed with. The application for condonation of delay is taken up for consideration. Hard learned advocate for the appellant, hard learned advocates for the parties, peruse the petition filed. Upon perusing the petition and upon hearing the learned advocate, this court is of the view
Can 2 stay?
that the appellant has made out sufficient cause
Can 2 stay?
for
1 condonation.
referring this appeal after the PDA, the learned advocates have made out sufficient cause in preferring this appeal after the period of limitation. Thus, delay in preferring this appeal is condoned and the appeal is admitted. The application for stay Can 2 of 2026 is taken up for consideration as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be an ad interim order of stay of the judgment and award dated 18th day of December 2025, passed by learned Judge, Bench 4, City Civil Court, Calcutta, in MSC case number 392 of 2020 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire compensation is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this appeal. As the respondent number 1 and 2 is represented by learned advocates, service of notice upon respondent number 1 and 2 is dispensed with. The trial court records be called for at the
My
special.
lord, they are with me. My lord, 35 copies are here with me. Trial court records. It's only on quantum. My lord, in usual course. Yes, yes.
The trial court records be called for.
Yes, it's
The
called for.
the informal paper books be prepared and copy be served. Liberty to mention after 5 weeks.
Grateful to your lordship.
My appeal, my lord. Appeal for the first time, my lord. I have deposited the statutory amount of 25,000. Yeah, no, and one. जिधर नहीं करो नहीं the appeal is within time, my lord. Stay.
Okay, only stay.
Only stay.
Yes, learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 26/11/2025, passed by learned additional district judge, 5th Court, Malda, in MSC case number 347 of 2016. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court. Such deposit shall be made within 5 weeks from date.
This statutory amount.
Anyway, that is implied. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The appellant shall cause service of notice upon the respondents, both personally through registered post as well as through the department by filling up necessary requisites and forms. The trial court records be called for.
I have the certified copies, my lord.
The trial court records be called for and the paper books be prepared on arrival of the trial court records. Liberty to mention after 5 weeks.
My lord,
Item 92, yes.
I am petitioner. So my senior engaged other court.
Okay, not today.
Please sort over, sir. Please sort over.
What do you want? Not today.
Short pass over.
Okay.
My lord, the 93's insurance appeal is appearing for the first time. My lord, I have made the statutory deposit. There is no delay in this case, my lord. I was praying for interim stay.
Yes, learned advocate for the appellant insurance company is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 10/4/2026, passed by learned additional district judge, first track 3rd Court, Howrah, in MSC case number 106 of 2023 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The appellant shall cause service of notice upon the respondents, both personally through registered post as well as through the department by filling up necessary requisites and forms. The
Let
trial
the-
court records be called
called
for, and the informal paper book be prepared on arrival of the trial court records, liberty to mention after 5 weeks.
Obliged to my lord. I'm extremely grateful.
Thank you for my lord. This is the time for the respondent claimants, my lord. My lord, this is the matter your lordship will perhaps remember, my lord. On the last occasion, I submitted before your lordship that the insurance company has filed one application for
Yes, for a
Order
for
9 Rule 13.
amendment.
No, Order 9 Rule 13
Oh.
for vacating the expertise hearing or expertise order. And my lord, this is the certified copy. Your lordship on the last occasion directed me to submit a certified copy. This is the certified copy of Miss case.
So Order 9 Rule 13 is already pending.
Your lordship has directed me on the last occasion to take instruction to whether we want to proceed with the appeal or whether we want to proceed with the
Order 9 Rule 13.
yes. Your lordship, for that there are two orders are there. Already the miss case has been disposed of yesterday, and on 25/6/26 there's an observation already made by the learned trial court below. These are the orders, your lordship. The miss case is not no more pending, your lordship.
Now the question is, you see, as because you have exhausted a remedy, so that miss case is allowed or dismissed?
No, dismissed.
Dismissed for-
Non-prosecution. The accordingly on prayer learned advocate petition, the instant case is dismissed for
That
non-prosecution.
means you have withdrawn that.
Yes.
They have the two. Withdrawn, my lord. The withdrawn prayer has been rejected. But they were the case was-
The orders are there,
No,
your lordship.
देखिए order take 2.
in the miss case, my lord, written argument was filed also on our part.
Anyway, it is a that is dismissed for non-prosecution.
Yes, your lordship. Nothing has been done on merit. This is the previous order, your lordship.
So
So there is no impediment for the appeal too.
the appeal be heard out.
Yes.
My lord, when they have not taken any defense in the trial court.
Let us see
Yes.
what is there
In
in
I
the
have
points of law.
every order is an appealable order, your lordship.
So the amount is secured.
Yes, your lordship.
My lord,
25,000 has been statutory deposit. The entire amount needs
Now you do one thing, okay? It's better the matter be resolved. Go to Lok Adalat because you are enjoying a stay probably.
No, I'm not enjoying. That's the problem.
no execution
Okay,
case is also-
make you have already made the deposit.
The execution case
There
is
will be
pending.
there will be a short period stay,
Yes.
as you know.
L-
In the meantime, you go
Your
and
lordship-
get it
Your
resolved.
lordship, let a stay order be granted. We will secure it, and then in meantime send it to the Lok Adalat.
Yes. I will, thereafter, I shall take a report of the Lok Adalat.
Yes. No, your
Yes,
lordship.
no. You see, if the matter is settled, it is well and good. If it is not, I shall hear out the appeal.
Lordship, what I'm suggesting, we will go for the Lok Adalat. What I'm suggesting also is, your lordship, kindly, as the execution is pending, I've given execution order as well. Your lordship, the attachment order is going to be passed. Your lordship, kindly take the order number 6, the next order, your lordship. There's an execution, MSC execution number 84 of 25.
Yes.
Your lordship, now your lordship will find out with this, by this order.
Yes. I've gone through. Yes, record an order.
My lord, my humble submission is that, my lord, they have already taken the opportunity, my lord, to vacate the
They
expertise
have
hearing
paid the
order.
part amount. They are partly secured. Okay. I'll direct them to secure the entire amount. In the meantime, let them try and settle.
Yes.
Learned advocates for the parties are present. uh, learned advocate for the appellant submits that the earlier application filed before the learned trial court under Order 9, Rule 13 of the Code of Civil Procedure, Order 9, Rule 13 of the Code of Civil Procedure is withdrawn. Thus, there is no bar in proceeding with this appeal. Stop.
Well, I am sorry to interfere, my lord. It was not withdrawn. It was dismissed for non-prosecution.
On their application,
Yes,
not dismissed for default.
yes.
Thus, this application, thus this appeal, along with this application for stay, is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated
12 September 2020.
Oh, this delay is also not condoned.
Can one.
আচ্ছা সবার উপরে একটা করে দেবেন তো the application
But,
for condonation of delay is taken up for consideration
My lord, the copies were also not served upon us.
to serve a copy.
Affidavit of service is there, your lordship. We can serve it right now, your lordship.
Okay, it was served upon the parties.
Yes.
Learned advocates for the parties are present. The application for condonation of delay being Can 2 of 2026 is taken up for consideration. Heard learned advocates peruse the petition filed. Upon perusing the petition and hearing the learned advocates, this court is of the view that delay in filing this application should be condoned. Thus, I condone the delay in filing this appeal. So, Can 1 of 2026 stands disposed. Stop.
One thing, my lord. My objection may kindly be noted, my lord.
আচ্ছা ওখানে লিখে দেবেন hard learned advocates consider the objections.
There is a long delay, my lord.
218.
Yes, my lord.
Oh, there are more delays than that also.
In spite of service of several notice, they failed to appear.
The application for stay is also taken up for consideration as the appellant insurance company. The application for stay being Can 2 of 2026 is taken up for consideration as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be an ad interim order of stay of the judgment and award dated 12th September 2025 passed by learned additional district judge, first track 6th court Alipur, South 24 Parganas, in MSC case number 234 of 2023. Top. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this appeal. As the respondent number 1 claimant is represented, service of notice upon respondent number 1 is dispensed with. However, service be effected upon respondent number 2 through both personally through registered post with AD as well as through the department by filling up necessary forms and requisites. The trial court records is dispensed with at this stage. Okay, can you bring the trial court records? That is the special messenger cost.
Well, my client will not be able
Okay,
to hear.
the trial court records be called for and the paper books be prepared on arrival of the trial court records. Stop. As it is a claim case and there is a chance of settlement, let this matter go to the National Lok Adalat to be held in the month of September. Fix 18/9/2026 for report of the National Lok Adalat and further orders.
It's outright deposited.
I'm appealing on behalf of the appellant insurance company. There is no delay in the matter. I have deposited 25,000, my lord. This is my photocopy of the challan.
Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 6/5/2026, passed by learned additional district judge, fast track, second court, Islampur, Uttar Dinajpur, in MSC case number 41 of 2021. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The appellant shall cause service of notice upon the respondents both personally through registered post as well as through the department by filling up necessary requisites and forms. The trial court records will be
Usual
prepared
course I have.
and informal paper books be prepared on arrival of the trial court records. Liberty to mention after 5 weeks.
I'm grateful, madam.
My lord, 96 is the insurer's appeal. Appearing for the first time, my lord, I have made the statutory deposit. There is no delay in this case, my lord. I was praying for interim stay.
Yes, learned advocate for the appellant is present. As the appellant insurance company has deposited the entire
No, my lord, statutory.
the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be an ad interim order of stay of the judgment and award dated 15th May 2026, passed by learned additional district judge, fast track 4th court, Alipur, South 24 Parganas, in MSC case number 148 of 2023 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The appellant shall cause service of notice.
My lord, since this appeal is confined only to the quantum, my lord, I was praying for dispensation with regard to the owner.
The
That is
service
respondent
of
number
notice
3.
upon the respondent number 3
Lordship,
is dispensed with.
grateful to my
Stop.
lord.
However, service be effected upon respondent number 1 and 2, both personally through registered post as well as through the department by filling up necessary requisites and forms. The trial court records be called for
Lordship, my lord, I've got a certified copy.
and the informal paper books be prepared on arrival of the trial court records. Liberty to mention after 5 weeks.
Extremely grateful to my lord.
My lord, I'm for the 7. My lord, I pay for the insurance company. My lord, I have deposited the statutory deposit. I'm praying for the same order as 96.
Yes. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 20. 14/5/2026, passed by learned Additional District Judge, Fast Track First Court, Purbo Bardhaman, in MSC 45/2018 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire statutory amount as including interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The appellant shall cause service of notice upon the respondents, both personally through registered post as well as through the department by filling up necessary requisites and forms. The trial court records be called for and the informal paper books be prepared on arrival of the trial court records. Liberty to mention after 5 weeks.
My lord, first step, this is the
This is for stay.
stay, my lord.
Yes. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 18th May 2026, passed by learned Additional District Judge, 13th Court, Alipur, South 24 Parganas, in MSC case number 34/2018 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court. In the event the entire compensation is deposited within a period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The appellant insurance company shall cause service of notice upon the respondents,
By
both-
registered post with it.
both personally through registered post as well as through the department by filling up necessary requisites and forms.
My lord, respondent number 2, the service upon respondent number 2 can be dispensed with.
His presence is not required.
No, my lord.
আচ্ছা, just a minute. তাহলে ওখানে রেসপন্ডেন্ট না লিখে এটা করে দিন রেসপন্ডেন্টস নাম্বার 1. The informal paper books, the trial court records we call for and the informal.
The informal paper book can be made because I have the certified copy.
Okay, you have already prepared.
No, I have it.
Okay,
Later on.
the informal paper books be prepared and copy be served and the liberty to mention after 5 weeks. আচ্ছা, ওই জায়গাতে ওই ইয়েতে করে দেবেন was service of notice upon respondent number 1 তো তারপরে করে দেবেন service of notice upon respondent number 2 is dispensed with. না না ওটা করবে না, শুধু পেপার বুকস এর যেটা দিয়ে দিলাম ওইটা।
99, I am appearing on behalf of the appellant, my lord. There is no delay. I've deposited 25,000 and I have the entire set of certified copies, my lord.
Yes. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 2nd day of June 2026, passed by learned Additional District Judge, 4th Court, Asansol, Paschim Bardhaman, in MSC case number 47 of 2016 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The appellant shall cause service of notice upon the respondents, both personally through registered post as well as through the department by filling up necessary requisites. The trial court records is dispensed with at this stage.
My lord will call for it
Okay, the
in
trial
usual
court
course.
records be called for, and the informal paper book be prepared on arrival of the trial court records. Liberty to mention after 5 weeks.
Grateful, my lord.
Hundred,
101.
item number 100, your lordship, this matter, Mr. Singh is appeared.
Should do 100.
His appeal is for enhancement. Application was disposed of, but directed to appear under heading to be mentioned. So it is appeal for enhancement. I have prepared the paper book
No, question is the matter was heard earlier.
hard earlier, your lordship.
When did I hear this matter?
No.
Your lordship, kindly see the last order, your lordship, condone that delay.
Picture देखिए.
Today he's saying I'm prepared the paper book and he's saying he matter heard earlier.
Your lordship.
Maybe
hard
some
earlier,
applications were
application
taken
was
up.
disposed of. Under direction to
No.
appear the matter under heading.
Main matter was not heard up because
No.
paper books is not prepared.
Your lordship directed to prepare the paper book, your lordship, and the matter to appear under heading to be mentioned, but wrongly appeared.
Anyway, come after 19th, let the matter go to Lok Adalat. Yes, record an order. Learned advocates for the parties are present. As there is a chance of settlement in this matter, the matter is referred to the National Lok Adalat to be held in the month of September. The paper books is ready.
Ready.
The paper books file be kept with the record. Let this matter appear on 21/9/2026 for report of the National Lok Adalat and further orders.
Your lordship, I have already served a copy of the paper book.
Okay.
Mr. Chief. It is-
I am for the claimant respondent, Mr. Ganguly from the appellant. Lordship, he is the appellant.
Your lordship, the can 2 needs to be disposed of. The stay needs to be made absolute.
So case and counter objection.
There's a counter objection already listed as next matter.
So what is the ground?
Your lordship, my ground is, I haven't gone through. Your lordship, it can't be settled here in Lok Adalat.
No, Lok Adalat হবে না।
No, earlier it went.
Huh?
No.
Earlier it went.
No.
No, I'll keep the, no, what is this can 2?
Can 2 is a stay. The stay.
No, I'll keep the matter on 21st or something like that. Okay.
Yes.
In the meantime, go and try. If it is not settled, I'll take it up on 21st.
Perhaps the grounds they have taken, there is this 1634, so 5 lakhs is the amount. Their quantum is not the issue.
So quantum is not the issue.
Naturally, so 5 lakhs they have already all the tribunal awarded.
Non-involvement.
So what is the ground of challenge?
Non-involvement.
Non-involvement.
Okay.
So
Yes, record an order.
Yes.
Learned advocates for the parties are present as the entire statutory, entire compensation amount is deposited. The ad interim order of stay shall continue till disposal of this appeal. Paper books are ready.
Fine. Already fine.
Okay. As the paper books are ready and the matter is ready for hearing, let this matter appear for hearing on 22/9/2026.
22 prior to this, because of the plea they have taken is covered by lordship judgment. Absolutely
It's
covered
okay.
by lordship judgment.
See, 2 weeks the bench will not sit. This bench will resume from 9th.
Yes, lordship.
So that is why 22nd.
Time.
Huh? Yes, where are the paper books? It's not in the record.
Yes, the paper is there.
Okay, 22/9/2026 at 3 p.m.
ঠিক আছে,
PM lordship.
3 p.m. ঠিক আছে, হয়ে যাবে। 29 তো
কিছু লাগে না, শুধু অ্যাবসলিউট করে নাও। অনেক টাকা।
এটাই
My lord, I am for the appellant owner of the vehicle, my lord. My lord, previously, my lord has passed an interim order of stay, which is expiring tomorrow, my lord. So I'm, my lord, praying for,
File that indemnity bond.
yes, my lord, this is my affidavit of compliance. indemnity bond and special messenger cost, my lord had directed.
My lord, I need to say, my lord, only one thing. My lord, when the insurers will not come up before your lordship against an award, my lord, the nationalized insurance company, your lordship asked my lord in each case to deposit entire award itself. In this case, my lord, your lordship, my lord, why the my lord, special preference be given to the claimant, my lord, or to the owner, my lord? Why not let, my lord, let them deposit that money, my lord? They want the stay off. So, my lord,
Because, my lord,
I can also understand, my lord, it is a little difficult for the owners at times. Let them deposit at least 50%, my lord.
my lord, because the claimants who are the main
Beneficiaries.
victims, they have already received the money. I have already deposited the, my lord, paper books. I am only requesting, my lord,
How
let a
much is
date,
the awarded sum?
8 lakhs odd. And the owner is an
confused
owner of an ambulance. It's a small ambulance.
My lord, does it
So,
give
my
the
lord,
special
I am
privilege to kill?
only
No.
because they have not proved their case. We'll show from the record, my lord. My lord,
Just
kind.
record an order. Learned advocates for the parties are present as the indemnity bond is filed in terms of order dated 1/7/2026. The ad interim order passed on 1/7/2026 shall continue for a period of 6 weeks or till further orders, whichever is earlier. Let this matter appear for hearing on 22/9/2026.
22nd September for hearing, my lord.
Yes,
My lord, all
3 p.m.
my lord, let it be recorded that the affidavit of compliance is already on record, my
Okay,
lord. I
the
am filing
affidavit
it.
of compliance file be kept with the record.
Deeply obliged, my lord.
Fees मिलेगा तो fees मिलेगा ना?
पता नहीं.
God bless you.
Your loss, item 44. If your loss allow me to deposit the check, otherwise the check will be.
Item 44.
Yes.
43, 44.
Only time.
No, 43.
43.
Item 44. Item 44 is cross objection.
43 and 44.
43, Oriental Insurance Company versus Salma Begum. Okay, National versus Konlan Dangre. Yes, who is appearing for the claimant? Yes, record an order.
44.
No, এটা ইয়ে আছে 42 নাম্বার
42.
42 item 42 তে learned item 42 learned advocates for the parties are present. By consent of the learned advocates, the matter is taken up for consideration as the compensation check which is prepared by the insurance company is going to expire, has expired or going to expire, is going to expire. The time to deposit the compensation check stands extended till 24.
So add one line booklet.
Okay, 26/8/2026.
Department will act on the communication of the learning. Otherwise, if your loss is not.
No, order will be signed by today. Today or tomorrow, the order will be signed. So I made it 26.
92, my lord. I am appearing on behalf of the appellant, my lord. This is a case of, my lord, enhancement, my lord.
92, you are for the appellant.
My lord, in item number 92, I appear on behalf of the respondent number 2 insurance company.
Okay. Condonation of delay, which one?
My lord, can 1 is for condonation of delay. There's a delay of 394 days as they have prayed.
My lord, he is a 100% disabled party, my lord. For that reason, my lord, that.
Okay, and can 2 is for what? Okay, can 2 is a different issue.
One application is there, my lord, for exemption of the service upon the car owner, my lord. He is not appearing in the court below, my lord. He is not contesting.
Oh, are you challenging the quantum?
Challenging the quantum.
quantum. So my lord, the owner does not have any role.
Yes, record an order. Learned advocates for the parties are present. The application for condonation of delay is taken up for consideration. Heard learned advocates, peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that the appellant has shown sufficient ground for condonation of delay. Thus, delay in preferring this appeal is condoned. And
My lord will kindly record my objection to this.
upon hearing the learned advocates and considering the objections, this court is of the view that the appeal is admitted. As the learned advocate for the respondent number 1 insurance company has entered as appeared.
Respondent number 2,
insurance company.
Yes, my lord.
Okay. As the learned advocate representing respondent number 2 insurance company has appeared, the service of notice upon respondent number 2 is dispensed with. Stop. Further, as the respondent number 1 vehicle owner has not appeared before the trial court, the service of notice upon the said respondent number 1 be also dispensed with. Stop. The trial court records be called for by special messenger cost to be deposited by the appellant within 1 week, and the informal paper books be prepared on arrival of the trial court records. Yes, liberty to mention after 5 weeks.
My lord, I have just been served with the brief. I undertake to file my wakalatnama in the due course of the day.
Otherwise, I can do one thing. If you can settle the matter, let it go to Lok Adalat. Because you see, because before 5 or 6 weeks, I will not take up the matter.
Actually, my lord, what happened, my lord? Lower court considering the 60% disability, my lord. He's a tailor, my lord. So, my lord, his all earnings has been gone. My
Very, very well. Okay, let the trial court records be called for. Okay, let the matter, as there is a chance of settlement, let this matter go before the Honorable Lok Adalat to be held in the month of September. Fix 21/9/2026 for report of the National Lok Adalat and further orders. If it is settled, well and good. Otherwise, I will fix a date of hearing.
Grateful, my lord.
Item number 9, I appeared for the respondents. Last occasion, my learned friend argued, today I am supposed to, my lord, give my reply, my lord. In course of preparation, my lord, I found that the document relied on the judgment is not in the paper book. Nor, my lord, the trial court record has been called for. An incomplete paper book has been filed, and there are illegible documents.
On the last occasion, you argued the matter.
Yes, they argued the matter.
Or your senior?
Yes, senior.
You better you sit with your learned friend and see what is missing. On the next day, I'll take it up. In the event, if something is missing, you file a supplementary paper book.
Yes.
Not yet missing, everything is incorporated.
Okay. Record an order. Learned advocates for the parties are learned advocates for the LCR SCK.
Has not come, then court a lot
Huh?
of.
Oh,
Matter is
the learned advocates for the parties are present. Learned advocates are granted opportunity to verify, to peruse the records, and if necessary, to file a supplementary paper books. Let this matter.
My learned friend will file, Lordship. Yeah, I have.
I'll tell you what.
No, you are the appellant.
Lordship, I am appellant, but I have, Lordship, almost tried and I have several times.
Whatever it is,
Of a Lordship, respondent office. Thereafter, Lordship.
whatever is there in the trial court records, you just verify and file.
You will check and.
Let this matter appear on 10/9/2026 at 10:30 AM.
Dates has been gone. In this way, Lordship petitioner, appellant, Lordship, he has already lost his husband.
Anyway, I shall consider on the next.
Only documents I will rely with. It is your duty.
You please, both of you go through the records, sit together. Yes. Yes, next.
Next, my lord, I am not ready with this case today, and moreover, the
cause title has not been corrected in.
Application is disposed.
My lord, my lord, cause, let me submit, then you will. Item number 11, my lord, the cause title has not been changed by the department and it is a high value case, my lord, more than 2 crores. So I will need some time.
Some settlement, can it be settled?
Not yet. I will talk to them.
How much is awarded?
More than 2 crores. My lord, more than 2 crores.
No.
Yes.
How much is awarded by the
51,
trial court?
there are two matters. In one matter around 51, in the other matter around 61 lakh.
Okay. So is there any chance of settlement?
I will talk to them, my lord.
So better, I'm granting you opportunity. I'm directing again the department to carry out the necessary amendment. I'm keeping the matter after some time. The matter will go to the Lok Adalat on, I'm fixing a date for report of the Lok Adalat.
Well,
You see, we talk with your clients.
well,
In the meantime, I may file the paper books.
Yes, learned advocates for the parties are present.
file
Let
the
the-
paperwork on that date when it will come.
Okay, no, let it be filed. Let the informal paper books filed be kept with the record. In both the matters you are filing. আচ্ছা দুটোতে same order হবে. That is item
10 and 11.
10 and 11. Paper books file be kept with the record. The necessary rectification is in the cause title be carried out by the department. Stop. As there is a chance of settlement, let this matter be referred to the National Lok Adalat to be held in the month of September. Fix 21/9/2026 for report of the National Lok Adalat and further orders. If it is settled, you talk with your client. If it is settled, well and good. Otherwise, I'll hear out the matter.
My lord. I'm grateful, my lord.
বলছে একবার সেটেলমেন্টের স্কোপ করে দেখুন লোক আদালত আসে।
My lord, 12 is insurance appeal.
Yes.
My lord, this appeal is only on quantum. My lord, of course, my lord, I just now, my lord,
So
spoke to
there
my.
is no other grounds.
No other grounds. My lord, I spoke to my learned friend, my lord, that if we can reach any settlement, but he's not agreeing to it. My lord, then I have to get ready, my lord. If I can just tell the facts, my lord.
No, if the matter cannot be disposed today,
My lord, it cannot be disposed.
so I'll keep it on 21st. In the meantime, let it go to Lok Adalat. You talk with your clients.
Already returned, mine.
Oh, returned.
Yes.
Then your lordship will fix it upon 21st, my lord. My lord, the point.
First or 1 or 2 weeks just before that also. Acha, record and order. Learned advocates for the parties are present. On the prayer of learned advocates for the appellant, the matter stands adjourned till. দেখুন তো 15-16তে কোনো ফাঁকা আছে? হ্যাঁ? Okay. 21/9/2000. 21/9/2026 at 3 p.m.
My lord, 13 also, my lord, your lordship will, my lord, fix up another day. My lord, this is on the point of fake insurance policy.
Same date, let it be, or otherwise some other day.
My lord, whenever my lord pleases, my lord,
এই
whenever.
পরের ম্যাটারটা item 13, পরের ম্যাটারটা same order, but the date fixed is 23rd
23rd of September.
at 3 p.m. 23rd at 3 p.m. Who is appearing?
My lord, my lord.
Okay.
Yes, my lord. Senior friend is appearing. Obliged to my lord.
So lordship will be kind enough to call the hearing matters once now, because I believe there are no fixed matters at the moment.
She goes to hearing matter. Well, item number 8.
Just a minute, just a
I
minute.
have.
Okay, fixed matter গুলো হয়ে গেল?
Yes, yes.
Oh, there is another matter at 1 p.m. Okay, hearing matters, if both sides are present, I'll take it up.
No, only item number 8, Mala. It's
Item
the section
8,
5 application. Yes, Mala.
Item 8?
Yes, Mala. Yesterday, Mala, we have mentioned the lawsuit will not be there for 2 weeks. Mala, urgency that I cannot go before the order 41 bench, Mala, because the section 5 has to be allowed.
So today it is due to appear.
Mala, 8, item number 8, Mala.
Item 8, the presence of both sides is necessary.
Yes. Well, if your lordship takes it,
if
well,
you-
any tomorrow, well, because your lordship will be not sitting for 2 weeks.
Yes, so if you can bring the other side,
The other side, well, I don't know. I have served, well, I don't know who is
affidavit
appearing.
of service is there.
Yes, affidavit of service is there.
Because today there is no indication that the matter.
Yes, well, the only problem is
এটাকে
the
কালকে আপনি ওই 10:30 করে দিন আর কি।
very well, man.
আর 10:30 না থাকলে পরে আবার একটা সাপ্লিমেন্টারি করতে, কিন্তু মনে করি এটাকে 10:30 করে দিন দেবেন কালকে। না এখন বোথ সাইড আছে, যেহেতু বোথ সাইড আছে সেহেতু, আদারওয়াইজ নিতাম না।
Why the difficulty is that for 2 weeks I will not be able to proceed in the order 41 because there is a execution case file already.
Anyway, I have not given that indication. Tomorrow it will.
Yes, item number 8.
Tomorrow it will be taken up. You see, possibly you intimate a notice.
Well, I don't know who is appearing, my lord.
By the parties?
Well, it will be maybe 14 parties.
Okay. Tomorrow it will appear.
10:30 your lordship is fixing, my lord.
Tomorrow at 10:30.
Yes. সাহেব একটু 10:30 একটু রাখবেন, এটা নাহলে খুব মুশকিল হয়ে যায়।
Because after 12 is original side.
Yes.
Yes, hearing matters, both sides present.
সাহেব একটু কালকে একটু রাখবেন, এটা খুব মুশকিল হয়ে যাবে।
Item 130, my lord, both sides are present.
10:30 সময় থাকবে
130.
আইটেম নাম্বার 10:30 সময় থাকবে কালকে। একটু করে দিন, নাহলে 2 সপ্তাহ খুব মুশকিলে পড়ে যাবে, জারি করে দিন।
ও আপনার না?
আইটেম 2-3টে আছে, তার মধ্যে একটা হয়তো দেওয়া যাবে না, আর একটা ডেট পড়বে, ঠিক আছে? 1 নম্বর আইটেমটা your man. Okay, I believe item number 4 you are appearing. Oh.
No. Item 4 is unique.
No, by mistake. It should be some United India or something like that.
785
by mistake it is. Two o'clock, supplementary list.
My lord's memory is Baapre.
I try to
In the
remember.
morning also we were talking about that Kalimata transport, wherein my lord said that no, that is not the order.
No, that I know Mr. Pradeep Kumar appeared. The name is also very much striking in my
That's what-
memory.
So we were discussing, he also distinctly remembers what is specific order.
Kalimat, I know the name also.
Baapre.
He was not remembering, he mentioned the matter.
But I know that Mr.
Yes,
Pradeep
yes.
Kumar appeared.
That's what we were discussing.
Yes.
130
Item
এখন,
four,
এখন
I'm informing
130
Mr.
hearing.
Konik.
Yes. 2 p.m. the judgment will be delivered.
হ্যাঁ, সব হয়ে যাবে। সেটা আপনি জানেন না, আমি জানি না। ফাইল আমি জানি না, আপনি জানেন। 130, হ্যাঁ, হিয়ারিং এর 130। In 130, item number 164 and
130.
130. না, না, আমি কানে তুলে 188 and this 242. All these matters, both sides are there.
130, then
164,
160.
then 188 and 242.
তো বার করুন, আমি তাহলে আধ ঘন্টা পরে বসছি।
Lordship, please. এটা very
আপনার
No,
পেপার,
no, all three matters you are appearing, both of you are.
all 4 matters.
Any after 20 minutes I'm sitting, let him trace it out.
that matter is file trace out.
আচ্ছা, আছে তাহলে দিন।
In the meantime, if my lord's officers are kind enough to take out the other matters, we'll do this matter.
130টা দিন তাহলে।
One matter 269, both sides.
269, 163A. Okay, just wait, let me see how far.
Here, I am for the appellant.
163A, yes.
Only 166 Lordship.
166, yes.
I am for the appellant.
What is
Is
the ground of challenge?
My ground of challenge is that the deceased was the income tax payee. Lordship, kindly turn to page 65.
Sixty-five, yes.
Huh.
মিলবে না, এই তো 47।
Oh. আচ্ছা, আচ্ছা, ঠিক আছে।
So Lordship, Lordship, kindly see the observation of the the gross income is 1,58,584. Lordship, has got it, Lordship, and top
Yes,
is 65.
yes.
So that is affirmed, and one of the officers of the income tax department has come and deposed. So income of the deceased, there is no dispute. But Lordship, the observation of the learned tribunal that I have challenged. Lordship, kindly come to the judgment of the learned tribunal. Is 71. The observation of the learned tribunal is that he did not disclose his business. So his return submitted by the assessee as a self-return without going through the papers. The return in assessment year 2011 and 12, net profit was shown, so 1,58,326, but they did not inquire about the source of profit. And this return shows the assessment was not taxpayer. So that observation is not proper, Lordship.
But ultimately the income tax return is considered.
No,
No, was it considered
No,
at the
no.
time of computing?
No. Ultimately, the learned tribunal come to a conclusion that 12,000 per month is a just and proper, and accordingly assess the compensation. Lordship, one thing is what is the one point which goes against me?
This is the death case.
Death case. And one thing, and this is my first fold of submission, and second fold of submission will go against me. That is the learned tribunal applied 17 multiplier. It should be 16 multiplier. That should go against me. And third fold of submission before your Lordship, the learned tribunal did not consider.
No, 16, that should be, anyway, whatever is right, that has to be considered. Okay, 16 has to be considered.
17 has been considered. So
Very
that-
well, whatever it is,
Yes.
that has to be considered.
And Lordship, next page 76, Lordship will found the learned tribunal did not consider any future prospects. That has to be considered.
What should be the percentage?
Percentage is 40%.
Anyway, the interest is to be reduced also.
No, the interest already I have received, that amount as per whatever learned tribunal that I have received.
No, is there any, it is whose appeal? Your?
My appeal.
There is no cross objection, so there is no scope to reduce interest.
No, Lordship, the whatever amount Lordship will enhance, that amount will be 6%, that I will not do any controversy.
Because you see,
Will remain.
I'm accepting the submission. And lordship, the future prospect, the future prospect is not awarded by the learned, that should be 40%. And lordship, the general damages, here brother and sisters the claimant, so general damages might be 30,000 plus 10% per year. It should be 36,000. It should be 36,000 because of that. No, not that. Because of brother and sister, the loss of consortium, spousal consortium, that is not
Bachelor.
bachelors. And here
Bachelor means filial consortium.
No, brothers and sisters.
brother and sister.
File claim case.
Brothers and sisters, parents are not there.
No, parents, and that evidence is
Okay,
there.
brothers and sisters, there is no scope of
So
consortium.
only 36,000 they are entitled.
No, whatever is observed, granted by the tribunal.
Landowner did not observe anything on
So
that score.
4,500.
Landowner awarded only 4,500. The instead of that,
Anyway, you see,
36,000.
so far you see brothers and sisters, that consortium concept is
No,
not there.
because of lordship,
Only loss of estate and
yes,
Funeral.
that is 36,000. That is 36,000.
36,000. Yes,
Because of
what
it-
you say?
30,000 plus
ছেড়ে
lordship,
দিন, ছেড়ে দিন।
10,000. Yes.
My lord will record my objection and my lord will dispose.
Okay, give me the calculations.
Mrs. Paul prepared.
With his consent.
Yes, obviously.
না দেখো না কি দেখছি
Yes, record an order. Learned advocates for the parties are present. Hard learned advocates. The appellants before this court were claimants in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 16th May 2015 passed by learned additional district judge, first track court, Asansol, Paschim Bardhaman, in MSC case number 9 of 2013. Stop. The case of the claimants before the learned trial court may be summed up thus. On 15/4/2012, at about 2:40 p.m., when the victim was proceeding towards Raniganj Bazar side from Sahebganj side by riding motorcycle being number WB38 capital X -3610 at that time near Sahebganj More, Chanachur factory under PS Raniganj. Another motorcycle being number WB38 capital Z -9220 driven by its driver rashly and negligently dashed the said motorcycle from behind. Stop. As a result of such accident, the victim sustained fatal injury and fell down on the road. Stop. He was shifted to Begania Health Center, where he succumbed to his injuries. Stop. The petitioners are suffering acute financial crisis on account of the death of the victim. Stop. Pursuant to filing of the claim case, notice was issued upon the opposite parties. Opposite party vehicle owner did not contest the case. Stop. However, opposite party insurance company contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. এটা ঠিক আছে, hence ঠিক আছে, page 76. The appellant's claimants, being aggrieved by the judgment and award passed by the learned trial judge, has come up with the instant appeal. Stop. Learned advocate for the appellant submits that the learned trial judge erred in considering the income of the victim as rupees 12,000, although the claimants filed the income tax return which was submitted by the victim. Stop. Learned advocate further submits that the learned trial judge erred in not considering the future prospect of the victim. Stop. It is also submitted by the learned advocate that the compensation awarded by the learned trial judge should be enhanced. Stop. Learned advocate appearing for the respondent, United India Insurance Company Limited, disputes the submission of the learned advocate for the appellant. Stop. With regard to the submission of learned advocate for the appellant, that the learned trial judge did not take into consideration the income tax return and simply observed and simply proceeded on the ground that the income of the victim should be rupees 12,000. It appears from the order of the learned trial court that the learned trial court did not accept the income tax return of the victim relied upon by the claimants simply on the ground that the nature of business is not disclosed. Stop. Thus, it is well settled in different judicial pronouncements that income tax return is an authentic document on which the courts and tribunals dealing with motor accident claim cases can rely to ascertain the income of the victim or the injured victim or his family. As the officer of the income tax department has deposed in this case and it is found that the income tax return are genuine, there is no scope for the court to ignore the said income tax return and to consider the notional income of rupees 12,000. Thus, the income of the victim should be considered as rupees 1,58,584 per annum. Stop. In the event the income is considered as rupees 1,58,584, 40% future prospect being added, the total income comes to rupees 2,22,017.6 paisa. Stop. 50% should be deducted on account of personal expenses, which is 1,11,008, and the annual dependency loss comes to rupees 1,11,008.8 paisa. Stop. The multiplier of 16 applied, the total compensation comes to the total dependency loss comes to rupees 17,76,140.80 paisa. Further, on account of general damages, the claimants are entitled to rupees 36,000. Stop. Thus, rupees 18,12,140 is the total compensation which comes by arithmetical calculation. Stop. However, this court is of the view that compensation of rupees 18 lakh is just and reasonable. Stop. Hence, this appeal, FMA 4623 of 2016, stands disposed. The judgment and award dated 16th May 2015 passed by learned Additional District Judge, Fast Track Court, Asansol, Paschim Bardhaman, in MSC case number 9 of 2013 stands modified to the extent that the appellant's claimants are entitled to rupees 12 lakh from the respondent number 1 insurance company. Stop. The respondent number 1 United India Insurance Company Limited shall deposit before the Registrar General, High Court, Calcutta, rupees 12 lakh along with interest at the rate of 6% per annum from the date of filing of the claim case till today. Stop. Such deposit shall be made within 8 weeks from the date of communication of this order. In the event compensation awarded by the learned trial court is already paid or deposited, the balance amount be deposited.
Balance amount is 5,71,500.
The balance amount of
5,71,500.
rupees 5,71,500.
And therein my lord had just stated 12 lakh, it should be 18 lakh.
ওটা 18 লাখ করে দিবেন যেখানে 12 বলেছি
71,500
be deposited by the respondent number 1 insurance company. The appellant's claimants will be entitled to withdraw the compensation upon compliance of necessary formalities.
Equal share.
In equal shares.
5,71,500 along with interest.
Oh, same. That is there already. 5,71,500 along with interest at the rate of 6% per annum.
From the date of
The
filing of the-
deficit court fees.
If
be-
any lordship,
No, it has to be. There cannot be if any. Enhanced compensation, definitely there will be deficit court
Absolutely,
fees.
absolutely. I'm not on that. Lordship will say all formalities that will be covered by that. So my one humble submission is that. Lordship,
No, no, they will let the deficit court fees be paid.
If any.
No, no.
Because of lordship, kindly see the appeal value is lordship, kindly see appeal value is 16 lakhs.
বেড়ে যাচ্ছে তো 18 লাখ হয়েছে না?
Very well. Deficit court fees, I will deposit. Kindly, one thing I.
How many days you will deposit? Within how many days?
Lordship, that will deposit lordship.
No, deposit means how long will you take to deposit?
Because of lordship, there is some difficulty. Either they will deposit before the tribunal or I will be with the online. So once lordship was to deposit the court fees, so prior to that, I should deposit. Otherwise, the lordship department will not allow us to withdraw the amount. So lordship allow direct me to deposit the court fees.
Yes.
And lordship, another submission is that the case filed on 31st July 2012.
That is not necessary. Okay, I have stated.
Because of lordship, otherwise they cannot calculate it because of that is not reflected in the judgment. Otherwise,
I have stated
taken up
from
the
date of filing
information.
of the claim case.
Yes.
Okay, date of filing of the.
Otherwise, I will take another lordship knows that I will take another information from the trial court. Then will supply to the
Date of filing of the claim case, which is
31st July 2012.
31st July 2012.
I'm grateful, my lord. Deeply obliged.
Yes. Yes, any other matter? Both sides?
164.
Bless.
269.
Yes.
Yours,
164.
you and? Okay, let 164 be taken up.
Lordship.
ওদিকে। Grateful, my lord.
Yes. Yes. Yes.
154. 216 আমার না ওনার 216
Yes, my lord, my learned friend was there. My lord, it mentioned on two occasions, my lord allowed that it let the matter appear as.
No matter is ready for hearing.
Yes, my lord, everything is there. Only thing, my lord,
You are appearing.
written notes on argument was there. But I do not know, my lord.
If the file is here, it will be.
matter was heard a number of times by Honorable Justice Ananya
No,
Bandyopadhyay.
but how many times I have heard the matter?
Not even once.
Then it's not that.
No, that's why
I thought that I have heard.
And
the matter.
they have withdrawn certain amount. They have already withdrawn
matter
certain
will
amount.
appear as to be mentioned. Even the written argument was there. It will take hardly 10.
It is there in the list. So whenever
It is appearing in the list.
yes, yes. Item
Anyway.
number ta কত?
appear করছে না.
It is item number, my lord, 171.
Oh, I'm sorry. Yes. It was direct. I'm sorry. Now, এটা to be mentioned থাকার কথা.
My lord will fix. My lord will,
I'll keep it after 9th
yes.
or 10th.
My lord will come back and
9th or 10th, I shall keep it.
grateful, my lord.
আচ্ছা এটা 171 টাকা ওই 10-11 তারিখের দিকে দিয়ে দিন আর কি।
হ্যাঁ।
Anyway, you see, this matter both sides. If present after on 10th or 11th, I'll take it up.
Yes, only thing, my lord, they are practically, my lord, not even able to, my lord, have their 1 square meal. This is the situation. A part payment has
No,
been
but
made.
part payment is made.
Part
How
payment,
much payment is made?
6 lakh and odd.
How much was the awarded sum?
17 lakhs and odd.
17 lakh.
Yes.
They have
now,
6 lakh and odd.
okay, so 17 lakh is the awarded sum, and you are challenging the quantum. Okay. Now, without
Lok
prejudice.
Adalat.
No.
No.
Yes, if you agree that is there, you can go to Lok Adalat. But without prejudice to the rights of the parties, let him withdraw another 2 lakh.
But I don't have the brief with me today. I just need to go through whether I'm challenging on quantum only or not.
No, because unless you are challenging on quantum, how is he permitted
No,
to withdraw?
probably maybe driving license issue was also there, wherein I need to recover from the owner.
Driving license issue is also there.
I don't remember. If my lord will kindly take it, এক minute. If my lord will kindly take it up tomorrow, I'll bring the brief.
Okay, so that I can consider on that issue.
Yes.
That temporary.
But
anyway,
I just need the my papers just to go through it once,
there are
my
two
lord.
things. One is this, let him withdraw at least 1 lakh or 2 lakh, and I'll send it.
Lordship will.
That would be better if both of you come ready tomorrow.
I'll come.
Because the appellate side will be taken up to 12.
My
okay?
lord. I will bring the brief.
So mention tomorrow.
Lord.
Sorry, my lord. Sorry to my lord.
Anyway.
Grateful, my lord.
ওর দুটো বার করে রাখুন।
Rahul, aste.
Yes, call the list.
269, 164 টা?
164.
ভুলে গেলাম তো মাই লর্ড ওঠার আগে। আচ্ছা চল। Then
One. I think 169 টা call করুন তাহলে।
Yeah,
269.
yeah, my lord, I am for the appellant insurance company.
Yes.
My lord, page 35 to 37 of the paper book. My lord, the grounds of appeals are there. First, my lord, we have taken a delay of filing FIR, page 35. Roman 4. Then, my lord, we have taken
Delay in filing of FIR, how many days?
86 days. Then, my lord, we have taken, is not considering that as per pension particulars shown in the pension sheet of the claimant, which clearly shows that his pension is rupees 5940 per month, but the learned tribunal awarded 24580. Then, my lord, we have taken
Yes, what is the pension?
pension is page কোথায়? Pension page দাও।
Yes, PPS.
BPS. Page 13, 14. 13, then 14. In 13, it has been written 5940. Page 13, my lord.
Page 13. 13 of the paper book.
Yes.
It is not tallying, but this
Valid.
pages, okay, page 13.
Yes, my lord. There it has been in the top. My lordship may say the mool pension 5940. Okay. Then, my lord, page 16.
5940. Yes.
Then, my lord, page 16.
Basic.
Yes. Page 16. That is the payment order. Page 16, then 17. At the top, my lord, pension written 5940. Page 16.
15. Okay, 5940.
Yes, my lord. Then, Arki. Per month. Tick.
Yes.
Up to 13,326, my lord. That's all. Then, my lord.
Up to page?
This is up to 40, page 15. Up to 16, 17. Started from 13, then 16, 17. তারপরে এরপরে গ্রাউন্ড আবার করো 35, 37. Then, my lord, we have taken the ground.
How much is considered by the learned trial judge?
Trial judge has considered, my lord, in the final sheet of the order. Judgment abar karo. 6. Break up the
That is page.
কত page?
Page 30, Lordship, therefore the income of the claimant was 5940.
Oh, 5940.
5940.
In cross examination, he admitted that he is drawing rupees. Sorry. Thank you.
5940.
Yes, Lordship.
That
per
is
month.
the observation in which page?
Page, Lordship, page 30. Judgment page, Lordship, 12. Page 30.
Yes.
Lordship, paragraph 23.
Expenses so and so. Income of the claimant, yes, 5940.
Yes.
But Lordship, here observation is that, however, in cross examination, he admitted that he is drawing rupees 12,000 per month. That's
Cross
why.
examination. Is it an injury case?
Yes, my lord.
Yes, Lordship.
Oh,
Lordship.
then in injury, it's not a question of any loss of service or something. He's
Yes.
a retired person.
No,
Yes.
he's
Yes.
getting pension, my lord.
Yes.
Nothing has been lost. Regular pension he is receiving.
So, oh, he's a retired person, retired from government service.
Yes, Lordship.
Is getting pension. And the injury also, injury certificate, lordship, may kindly see the injury certificate. What number page?
Injury is Lordship, locomotive injury, injury certificate or page
The
61.
question is that
Page
it is not that
61.
he was in service, he lost the service
Yes.
or unable to do business.
Yes.
Simplicity
Yes,
or pension. Apart from pension, was he receiving any other thing?
No, my lord. He's page 20, lordship, may kindly come. Certificate of disability. Page 20. It's a case of locomotor disability.
Page 20.
Page 20, my lord. He is getting pension. His pension has not been stopped. He's earning. And it is a disability is temporary in nature.
Oh, how long? With how much are you willing to settle the matter?
As your lordship. কত তো settle করবি?
Thereafter, then only I can send it for settlement. Otherwise, I have to pass my own
Yes.
reasoning order.
Lordship, I have no objection.
If you
Your
fail
Lordship.
to settle, I'll have to pass my own order. It's better you take a chance for settlement. Thereafter, I shall.
Lordship, your Lordship passed order.
Otherwise, you see, this
is-
is a case. You have not lost anything, job, nothing.
Lordship, may
And
kindly
simpliciter pension is also being received. And how much is awarded? Total
total how much? 60.
16,64,000.
16 lakh 60.
So it's better you take your chance. Okay. Thereafter, I shall take up the.
My lord, may kindly pass the order, my lord, because the company is not willing to go there, my lord. And they are accepting whatever your lordship pass the order, my lord.
Lordship,
I shall do that. Okay. You see, the Honorable Supreme Court is encouraging that this type of petty
Lordship,
matter.
last occasion, the
they
matter
wait.
has gone
No,
to
no, this
end.
matter.
Yes, Lordship, but not company is
Oh,
not
this
ready.
matter was not settled earlier.
Yes.
Okay, okay.
Lordship, may kindly pass the order as your lordship pleases.
Lordship.
देखिए grounds are there.
So your ground is this is a case of pension and he is receiving the pension.
Receiving the pension. Nothing has been lost. And such an
Only
amount,
with regard to medical expenses and all these things.
medical
Loss of amenities and
Yes,
Yes,
pain,
that is
suffering.
correct.
that's
Medical expenses, Lordship, 3 lakh.
So you see here it is an injury case.
Yes,
injury case,
So
my
where is the scope of this 1/3 personal expenses deduction?
lordship.
Lordship,
on-
this is also wrong, Lordship.
What
Wrong,
basis
my lord.
this is
50%
deducted-
will
this
be
is done?
deducted.
Everything is wrong, my lord.
Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 10/9/2026.
I'm grateful by that.
Lordship, my only one submission, Lordship, the learned judge is wrong. 1/3 is not deducted, 50% will be. Lordship,
No,
that's
where
what-
is the scope
but-
in injury case? To injury means percentage of disability,
Yes.
loss of
I
income,
appreciate, I appreciate.
no scope of.
But Lordship, my one submission, the person is age, Lordship, for 60 years. But Lordship, 60 years, my life expectancy is 74 years now. But on that ground, your Lordship.
That's a different, that heading is also considered.
Lordship, that's
The
Ground,
entire
ground.
thing a person
That
is
will be-
getting, and you see,
Yeah.
it's not a case that doing business or doing job or whatever
Lordship.
it is.
But Lordship, he is not able to locomotive, Lordship.
Oh, simplicity, a person is receiving pension.
Lordship.
Lordship, I appreciate that thing, but Lordship,
আমি 9 তারিখে ইয়েতে 9 তারিখে 10 তারিখে দুপুরবেলা দেবো তো অসুবিধা হবে না 9 তারিখে তো কোর্টে জয়েন করছি রেকর্ডটা পাঠিয়ে দেবেন কালকে
হয়ে যাবে তো
রেকর্ডটা পাঠিয়ে দেবেন ওকে
I'm grateful.
Lordship, I am grateful.
My lord, item number 188, both of us are here, my lord, if it could be taken up.
188. Okay, I have called earlier matter 170. Let me take up that matter first.
দিয়ে দে আমারটা দিলাম ওর তো দিয়েছে একসাথে দিয়েছে ওই তো বলছে দিয়েছে রনিতকে
শুরু করুন না পেপার বুক দেওয়া আছে This is a premium check dishonor case, my lord. Owner had been directed to pay. It's a very short matter.
No, these type matters cannot be short. This check dishonor is a complicated matter.
It is why I say it's short because
recover, my lord.
Of course, it goes against me, but that
So you settle if you think it is short, you can settle the matter. You go and settle it.
I'm ready to, my lord, but company won't.
No, you means your client.
The only thing is that AD card.
Then let us do one thing. Partly let it be borne by the owner, partly by you. How much is awarded?
25 lakh.
25 lakh. It's a huge amount. Anyway, partly the insurance company let the insurance company bear, and partly let the owner bear.
My lord,
That I can pass.
my lord, rules not speak, my lord. This is a not of this common, my lord. Owner have no knowledge at all. You can see judgment, my lord.
So there is a direction upon the vehicle owner to pay.
Yes.
So the owner has not come and challenged that he was not served. The liability is upon the owner, but the owner has not come.
My lord, as per tribunal observation that claimant must be issued summon to the owner. Why the check at this owner? This is not my duty to third party.
The question is, you see,
Insurance company did not serve any notice, my lord, to the owner.
the vehicle owner, you see, first of all, has not challenged. I can do one thing, you see, subject to the agreement. Of course, without agreement, it cannot be done. This is a case of which year?
2016.
16, my lord.
16, because it is a case of long pending case. If
My
both
lord.
parties agree, 50% by the owner and 50% by the insurance company. At
My
best, that can be done.
My lord,
Otherwise, I have to decide the matter on merits.
without recording my consent, my lord.
No, that you see, without, then on what basis I shall do that?
My
No,
lord,
see,
make it an order of the court. My lord has ample power. My lord will make it an order of the court.
otherwise, that recovery.
Recovery already
Because that
passed by the Honorable High Court and Supreme Court.
May I make it very short?
Can
my
recovery, my lord.
Okay, let me see what are the grounds.
lord? My lord, that was not that the owner had received the intimation that acknowledgement that was not executed before the judge's
Not agree. Edicard and
আমি my lord বুঝে গেছেন আপনি ওখানে বলুন
my lord.
Okay, let me see the order of the trial judge.
2 grams.
Regarding quantum, okay, there is no challenge.
quantum.
Oh, because nothing is awarded against you.
My lord, quantum on
quantum
teacher,
also he has challenged it will enhance
teacher post were not given, my lord.
Okay, let me see the findings.
Findings, it's at page 75. Relevant portion.
74.
Yes, it starts. And regarding this check, my lord, it's at 75.
Oh, that last paragraph.
Yes, now the question.
Now, one thing you see, this is with regard to the dishonor of check for that particular year.
My lord.
I can do one thing. I can grant you an opportunity to take instructions whether that this person is still your client or not. Because thereafter the bona fideness and all these things can be considered. That so you come take instructions.
Very well, madam.
See whether this person is still.
My lord.
Yes, record an order. Learned advocates for the parties are present. Hard learned advocates. As the dispute involved in this case is the dishonor of check issued by the vehicle owner upon the insurance company. Stop. And the direction of the learned trial court upon the vehicle owner to pay the compensation. Stop. Upon considering the facts of the case, this court is of the view that the respondent insurance company should take necessary instruction as to from which date the vehicle owner took the policy, when the said check was dishonored, and whether the said vehicle owner respondent is still continuing with the said policy.
Lordship.
Upon obtaining the instructions, the learned advocate shall come with necessary, shall file the report. Let this matter appear on 15/9/2026 at 4 p.m.
15তে 4টের সময়। I'm grateful, my lord, deeply obliged.
The 1 p.m.
In this case, my lord, you will also direct me to file the written argument. Appellant has already filed the written argument.
Oh, hearing was concluded. Okay. This is the claim case.
WC case, my lord, injury case.
Okay. Yes, record an order. Learned advocate for the respondent insurance company is present. Learned advocate files the written notes of arguments. Let the same be kept with the record. As the hearing of these, as the appellant has already filed written notes of argument, the hearing is treated to be concluded. Let this matter appear for judgment on 15/9/2026.
My lord, your lordship direct me to have the copy upon the learned advocate of the trial court and call for the records of the case. A record is there. And the record is come, my lord, but today, my lord, your lordship, as per hearing, my lord, your lordship.
Anyway, let it be not today. On the next date, it will be taken up. On the scheduled date, it will be taken up. It will remain.
I already served, my lord. They received the notice.
File your affidavit of service.
Ready.
On the next day, I'll take it up. So same.
Same.
Same, not today. 22 তো মেনশন করে ফিক্স করেছিল না, একটা বাজেনি তো এখনো, তাহলে একটু ওয়েট করুন তাহলে।
I beg to appear for the preemptor petitioner, my lord.
We are appearing for the
Item 15,
15, my lord.
you are for the petitioner.
Petitioner, my lord.
Yes.
My lord, the affidavit of service.
You are for
we are for the opposite party.
all the opposite parties.
Yes. Let
What is this can 2? What is can 2 for?
Can 2 is for, my lord, reimposition of the interim order, my lord. My lord, though the interim order expired on 26th of March 2025.
a copy
My lord, the issue involved in this revisional application is, my lord, course error, my lord, that is pending before the larger bench.
No, question is it with regard to preemption matter?
Preemption, my lord, we are the preempters.
submit below the
Anyway, come after 2 weeks, you obtain instruction what is the present position of the matter. Thereafter, I shall see to it.
Hello.
Yes, record an order. Learned advocates for the parties are present. Let the affidavit of service file be kept with the record. Learned advocates are requested to obtain necessary instructions about the present position of the matter which is pending before the Honorable Special Bench. Let this matter appear on 22/9/2026. The interim order granted earlier is reimposed and shall continue for a period of 6 weeks or till further orders, whichever is earlier.
Lord, I have filed the affidavit of opposition that may be recorded, my lord.
The affidavit in opposition file be also kept with the record and copy be served.
Yes, copy has already been served, my lord. Yes. এই তুমি আমাদের একটা কপি দেবে is that number 2? ঠিক আছে আমি জেরক্স করি
এই আরেকটা ম্যাটার একটা সময় আছে ওটা ওই যে ওই সিও এই না ইয়েটা এই যে আপনার একটা সময় আরেকটা কটা ম্যাটার আছে সিও যেটা ওইটা হয়ে গেল না, ওটাতে তো টাইম দেওয়া নেই।
My lord,
Just a minute. এটা একটা কোথায়, এটা একটা সময় কোথায় লেখা আছে 22-এ? এটা 2 PM না, এইটা তো একটা সময় হয়ে গেল। আর কোনটা আছে?
46
এটা একটা সময় নেই, এটা তো up to date।
আচ্ছা ঠিক আছে।
কিন্তু এটা তো মেনশন করেছিল আর্জেন্সি দেখিয়ে যে আর্জেন্সি আছে বলে। এটা কিন্তু কবে, এখানে কি টাইমিংস দেওয়া আছে? এটা না, এটা যে আজকে হবে আদৌ সে ইন্ডিকেশন আছে কিছু? ইন্ডিকেশন নেই কিছু। নির্ঘাত মিস্টার পাহাড়ি আছে বলে তাই জন্য ওটা হলো। এটা ওরা আর্জেন্সি দেখিয়েছিল, তাই জন্য এটাকে লিস্টে দেওয়া হয়েছে আর কি। এনিওয়ে 2টোর সময় এসে যদি করে তাহলে দেখতে হবে আর কি। Yes,
At 2 PM, can item number 188 be taken? We are both here, my lord.
PM it won't be taken up. If my lord
Of-
desires,
It can be taken up now also.
also.
no,
Only
one-
quantum.
Fix. But then we are here. We leave it to my lord. Grateful.
188.
Yes.
So is it with,
Whenever my lord.
no, is it only with regard to quantum?
Quantum and pay and
Pay and
recovery.
recovery issue is there. It won't take much time, my lord.
Only because of that we can't go to local. That is the difference.
Okay, after the fixed matters are taken up, please
My
remind me.
Keep your best, my lord.
140, my lord.
Item?
Not 140. HON'BLE appearing in this for the appellant.
He'll be coming. Second half.
140?
140.
Yes.
Any day fixed for any day, my lord. Otherwise, he is not.
2 PM, 2 PM.
Oh, 140. I'm sending it to Lok Adalat. Thereafter, after when
Previously, it was not settled, my lord. My lord kindly hear out the.
we 140, okay. But this 2 weeks, this bench will not sit, okay? So,
2 PM, Sanjay Pal.
okay, thereafter, you have to come after 10th.
HON'BLE is coming.
See, I
Yeah,
can
it
fix
will
it.
happen.
I can fix it after 10th, okay? But as because 2 weeks, this bench will not sit, I can fix the date after 10th.
10th, my lord, 10th.
Let the other side be present.
Your lordship on 17th. And my lord, the matter has been fixed on 19th yesterday, but the matter has not been come to the list. My lord, I have been told that the matter supplementary list was published yesterday, but my lord, today when I received the copy of the order sheet, in order sheet it has been written 19 September the matter has
Yes,
been.
because this bench will not sit for 2 weeks.
19 September is Saturday.
19th September. Anyway, then it has to be altered. So let it appear tomorrow. Has to be mentioned at 10:30.
17 তারিখ। কাল টু বি মেনশনে থাকবেন, একটা ডেট ফিক্স হয়ে যাবে।
তাহলে এক কাজ করতে পারেন, এটাকে আজকে তাহলে 3টের সময় কি 3:30-র সময় একটা সাপ্লিমেন্ট, 3:30-র সময় কাল সকালেও রাখতে পারেন, নইলে আজকে 3:30 সাপ্লিমেন্টারি 3:30-র সময় তাহলে ওটাকে ইয়ে
টুমরো
tomorrow it will appear.
Item number 70, my lord. Today morning,
Yes,
item number 70 today morning I have mentioned, my lord.
yes.
For application.
Just wait for some time.
1 to 3.
Yes. Yes, actually, the judgment is not made ready. It will be delivered on some other day. Yes, record an order. Today is fixed for judgment. As the judgment could not be made ready, let this matter appear on 21/9/2026 for judgment. 21/9 for judgment.
Number 5.
Hence, this appeal FMA 14 of 2026 stands disposed. Judgment and award dated 27/11/2015 passed by learned additional district judge Islampur, Uttar Dinajpur in MSC case number 69 of 2011 stands modified to the extent that the appellant's claimants are entitled to compensation of rupees 5 lakh from respondent number 1 Bajaj Allianz General Insurance Company Limited. The respondent number 1 shall deposit rupees 5 lakh along with interest at the rate of 6% per annum from the date of filing claim case till today. Such deposit shall be made before the Registrar General High Court Calcutta within 8 weeks from the date of communication of this order. The appellants will be entitled to withdraw the compensation upon compliance of necessary formalities. The respondent number 1 insurance company is granted liberty to institute recovery proceedings before trial court upon conducting inquiry first and upon giving the vehicle owner an opportunity of being heard by following the procedure as laid down in the case of National Insurance Company Limited versus Liraza Bibi above.
So the HCR is set down by specialists.
LCR has come. Yes, deficit court fees are to be paid.
Take within 1.
Yes. TCRB sent and deficit court fees be paid within, or the special messenger cost be paid within 1 week.
My lord, what we could hear, my lord, your lordship stated the award dated 27/11. It is 27/1. If I, my lord, I hope I have not heard wrong.
27. Okay, 1/2015.
Lordship.
No, in the paper book it is
My lord,
something like that.
I've got a copy of the award, not just 27/1. My lord.
27/1.
Lordship.
Okay. Okay.
Obliged, my lord.
Hence, this appeal, FMA 785 of 2026, stands disposed. The judgment and award dated 1/10/2024 passed by learned additional district judge, 6th Court, Paschim Medinipur, in MSC case number 363 of 2018, stands modified to the extent that the appellant is entitled to compensation of rupees 20 lakh. Stop. The respondent number 1, insurance company shall deposit rupees 20 lakh along with interest at the rate of 6% per annum from date of filing claim case till today. Such deposit shall be made within 8 weeks from the date of communication of this order. In the event compensation awarded by trial court is paid or deposited, balance deposit be made. The appellant claimant will be entitled to withdraw the compensation upon compliance of necessary formalities. Deficit court fees on enhanced compensation be paid within 4 weeks.
Obliged, my lord.
Yes. Item?
Item number 70, my lord.
Yes, item 70.
70, my lord.
Yes, what is the clarification to be made?
Yes, my lord. What happened, my lord? When the case was filed and when the award was passed, my lord,
Yes.
name of this claimant was Morjina Mullik.
Yes.
And my lord, in support of that, my lord, I have filed the election commission, the voter identity card. As my lord.
No, right from the very inception, the name is wrong.
No, not. It was not wrong. It was Morjina Mullik. It was his hard name. Thereafter, my lord, in the year 2000, this case was filed in the year 2011, my lord. Now, in the year 2016, Aadhaar card, etc. came. In the Aadhaar card, the name appeared as Morjina Bibi. But the husband's name is same, Morjina Mullik. I have annexed it with my petition. Thereafter, on the basis of the Aadhaar card, the PAN card was prepared. There also, the name appears as Morjina Bibi. Now, my lord, I have also annexed, my lord, the election commission voter information slip. There also, the name appears as Morjina Bibi. This is current.
So earlier it was Morjina
Mullik, and now it has become Morjina Bibi. And in support of that, my lord, I have also filed one affidavit affirmed before.
But you have filed an application.
First class judicial magistrate.
Yes.
Application, that is CAN 1.
Yes, CAN 1.
আছে CAN 1 টা দিন একটু।
CAN 1 not means CAN 1, CAN 4, my lord.
CAN 4, right.
Now, when my lord, we went to open the bank account, bank is saying that they will not open in the name of Morjina Mullik.
And
CAN 4. So this is the problem, my lord, that for which we can.
But shall I make it alias?
Alias, all right, that will serve the purpose, my lord.
Yes, learned advocates for the parties are present. By consent of the learned advocates, the matter is taken up for consideration. An application is filed by the respondents number 1 and 2.
One is dead, my lord.
Okay, respondent number 2 for rectification of the name from Morjina Mullik to Morjina Bibi. Stop. As the appellant is respondent number 2 is known as Morjina Mullik, but by virtue of the recording of the name as Morjina Bibi, let the name of Morjina Mullik, respondent number 2 herein in the cause title of the appeal be made Morjina Mollik alias Morjina Bibi. This application stands disposed. The amendments be carried out within 2 weeks.
And my lord, in the judgment also, my lord, the same rectification.
The cause title of the judgment of this matter be rectified accordingly.
Obliged, your lordship.
If you oblige me. Item number 16.
I am appealing for the
Item number 16, my lord, I am appearing for the appellant. My lord, in this case, though I have submitted the special messenger cost on the day on which the order was made, but LCR has not come yet.
The reminder be sent. Yes, record an order. Learned
LCR task.
advocates for the parties are present. As the trial court records have now not come, the matter stands adjourned to. দেখুন 15-16-তে ইয়ে আছে, কবে আছে? তো 16 16/9/2026
2 p.m.
at 2 p.m.
Yes.
As the trial court records have not come in spite of the deposit of the special messenger cost, the registrar administration LO and M is requested to look into the matter so that the trial court records come prior to the date fixed.
Item number 18 টা বলে দিন আপনি। Item number 17.
Lordship,
Item number 17, I am for the appellant, your lordship. On the last occasion, that is on 15th of July, my part argument was concluded. But
my lord,
their part,
most humbly, my lord, my senior, my lord, learned advocate Rajendra Kumar Gupta is trying to appear online, my lord, virtually, my lord, but due to some problem, my lord, might be he is not able to connect properly, my lord.
on the earlier occasion, he was not also present.
So you obtain instruction when you will appear?
My lord, on the next date, my lord, if your lordship may please, my lord,
No, on the next date. Which date? You just tell me that.
on any date, my lord, on any date, on any date. আছে অনলাইন হচ্ছেন তো রাজেন্দ্র কুমার গুপ্তা কানেক্ট হচ্ছেন আচ্ছা আচ্ছা তো মাইট হ্যাঁ তো I have to call my lord. I was calling outside my lord, but you might be due to some problem my lord. However my lord, I bow down to your lordship my lord. Kindly fix any date my lord. He will be appearing my lord. He will be making submission.
Record an order. Learned advocate for the appellant is present. Time is prayed for on behalf of learned advocate for the respondent. Thus the matter stands adjourned to
any date
21/9/2026 at 2 p.m.
lordship.
My written argument is also ready, your lordship.
My lord, written arguments my lord, I will be receiving.
I have heard this matter.
Yes, from
Let
my
this
part,
matter be
it was
treated
heard.
as a part heard.
21 তারিখ 21 তারিখ
21 বলছি রিটেন নোটস অফ আর্গুমেন্ট মোস্ট হামবল গ্রেট এক্সট্রিমলি গ্রেটফুল
18 my lord.
18 my lord, I am following the same order.
16 item note 16 and 18 both
The LCR has not come, though I have submitted the cost.
আচ্ছা item 16 এ যে অর্ডারটা হয়েছে ওটা করে দেন।
we are appearing for the
Grateful, your lordship. ওটা 21 তারিখে থাকবে তাহলে না 16
16
16 at the same time.
yes sir 16 at 2 p.m. obliged to
কি 3টের সময় কি 188 yes দিয়ে দিন
188. Hajar Art of 2024 FMA. 1008 of 2024.
Yes, call 188.
My appeal is solely based on quantum. And since there was no route permit, the fourth ground is that there was no route permit. Learned trial judge, my lord, held that there was no route permit and insurance company should be allowed to recover. But in the ordering portion, my lord, that is not there. No, I mean. And there's one cross objection, my lord, of my learned friend that is there in the paper book, my lord. And let it be treated as on days list, my lord.
Okay, cross objection.
The cross objection.
It is in the file as well.
আমার পেপার বুকটা দেবো মাই লর্ড না তোমারটা না দিয়ে দাও মাই লর্ড উইল কাইন্ডলি সি দিস পেপার বুক ফর দ্য টাইম বিং মাই লর্ড লেট দ্য ফাইল কাম পেপার বুকটা একটু দিয়ে দিন আপাতত এসে গেছে ঠিক আছে the deceased, my lord, she was a lady aged about 39 years and accident took place, my lord, in the year of 2022, 14th of December 2022. Deceased was a 39-year-old lady. She was traveling in a bus when the said bus capsized, my lord. The trial court, my lord, took the income to be 10,000 per month. As per the claim application, my lord, the victim, my lord, she was working at a grill manufacturing factory, and it is the case of the claimants that the victim was earning 15,000 per month. The learned trial judge, my lord, took the income to be 10,000 per month. That is what I have disputed in my, it's my argument that the income should be 5,000 rupees per month. Okay, notional income.
10,000 per month.
Yes, that was taken. My argument is it should be 5.
She was working in where? Grill
She was working at one grill factory, grill manufacturing factory.
What is the nature of that work?
Managers.
That my lord will kindly come to the evidence of PW2. It is at page 15.
Okay, page 15. The employer did not come.
No, this is the employer.
Oh, employer has come.
Yes, yes. Employer has come and
page
15, 1-5. And just given one single certificate, my lord.
Okay, as per claimant, victim was earning
15,000 per month.
15,000. Okay, that is evidence of PW2.
PW2 as well as PW1, I suppose, the husband. But this employer, my lord, had given only one certificate, salary certificate, that is at page 111. I dispute that certificate, my lord. 111 is the certificate. That is exhibit 18. It just says that victim was getting a salary of 15,000 per month as a manager.
Was working as a manager.
Manager, my lord. That is the only certificate as far as
or just an unskilled worker or something.
No. So that is the only certificate which I dispute. So this is regarding the income, my lord, learned trial judge at page number 29. I'm sorry, page number 30 dealt with the issue of income.
Grill manufacturing business.
Business.
The trade license is
no, not
16.
Trade license, no, nothing else had been given.
Exhibit 16.
Exhibit 16 is
Exhibit 18 is
trade
the
license of the employer, page 106. Yes, that is there at page 106, page 107 and 8.
yes.
At page 30, my lord, learned trial judge had dealt with this issue, third paragraph onwards. Page 100, page 30 of the paper book.
Yes.
It starts from that. Now the next point of determination is about the income of the victim.
Yes.
And thereafter at page 31, my lord, the contesting OP, though denied the income of the deceased, but such denial is not sufficient to lead the tribunal to think otherwise by ignoring the evidence of PW2, who claimed himself to be the employer of the deceased Taposhi Sardar and admitted himself to have issued a salary certificate in the name of Taposhi Haldar. So that Haldar and Sardar, that is where the contradiction lies.
Okay.
The employer, since having special knowledge about the salary of his employee, his evidence cannot be ignored simply because the
Oh,
contesting.
the employer has said Taposhi Haldar.
Taposhi, yes, Taposhi Sardar.
Taposhi
Sardar.
Sardar.
But the victim was Taposhi Haldar.
Oh, she met with a motor accident.
Yes. At
Okay. The victim was Taposhi
Haldar.
Taposhi Haldar.
Haldar.
And what did the employer say? That
I'll just come to that. It is at page number.
Taposhi Haldar 111.
In the certificate it says Haldar.
Haldar,
Probably in the evidence, my lord. I don't know where from that came. Page 15 also doesn't say anything about the name.
See, Taposhi. So far the documents are concerned, it is Taposhi Haldar.
Yes, yes, yes.
So far the employer certificate is mentioned as Taposhi Haldar.
Yes.
So what is the other dispute regarding name? The documents, Aadhaar card, Taposhi Haldar.
No, everything is, otherwise everything is okay.
It is there.
And finally, the learned trial judge, my lord, came to the conclusion that the income should be 10,000 per month at the time of her death.
Okay, just in one line.
Yes.
The learned trial judge has said Taposhi Sardar.
Yes.
Very well.
And
perhaps
I have gone a step further. I say it should be 5,000 notional income. So this is first regarding my first ground, my lord, income. The second being, my lord, general damages.
That right to recovery is given to you.
No, no, no. That has not been given. That had been.
But there is an observation.
Yes. The observation is at page number 34. In italics, it's written. And the lower portion, page 34.
Yes.
Thus, in the case in hand, the insurer is to satisfy the award first and then recover the amount from the insured in due process of law. But it had not been, the ordering portion doesn't reflect.
The ordering portion, right to recover, is not given.
No, no. This is one of my ground, my lord. This pay and recover.
Yes.
And general damages, my lord, 1,50,000 total had been awarded. It should be 84,000, my lord. There are the claimants are the husband, son, and minor daughter.
So deduction should be
1/3.
Deduction is yes, that is all right. Only the general damages.
Future prospect.
Yes, it had been granted.
Okay.
40% had been granted. Victim was aged about.
General damages, how much is awarded?
1,50,000. So it should be 84,000. This, my lord, will find from
1,50,000.
Yes, that had been granted, but I say that it should be 84,000. At page 32, my lord, It's there, this general damages.
Yes.
And at page 32, my lord will see it's there, this general damages, what I was praying before, my lord.
Page 32.
There being three numbers of claimants, page 32.
Yes.
There being three numbers of claimants dependents, the amount of consortium shall be 40,000 into 3, 1,20,000. Simultaneously, the claimants will get funeral expenses to the extent of 15,000.
Anyway, as because there is only wife.
No, the wife expired, husband and
Okay, husband and two children.
two children.
So 40,
Son, major son and minor daughter.
40,000 or 30,000 or maximum 44,000.
So this is there, and lastly, the interest. Interest, my lord, 6% was granted, and insurance company was directed to satisfy the award within 30 days.
Thereafter, penal interest.
Yes, 9% penal interest was awarded.
Penal interest.
So this is the entire crux of the matter.
That only with regard to the income, 15,000 has been claimed.
Yes.
But 15,000 the claimants have claimed.
1,000 is the claim with regard to the monthly income.
Yes, Malad will kindly come to the evidence of PW2 at page 15.
Yes.
Kindly see Exhibit 18, which is the salary certificate, saying that the victim used to earn 15,000 rupees. It has been marked as an exhibit without objection at page 15. The insurance company has objected to the trade license which has been exhibited, the trade license of the employer. That has been objected to at page 15, my lord. But the salary certificate which has been issued, that has been tendered into evidence and has been marked as Exhibit 18. It has not been objected to. I will just like to take your lordship to the cross-examination. It says that I run my business under the name and style of Haldar Engineering Works. I have been running such business in my name since 2020. Before that, my father used to run such business. I cannot file old trade licenses in the name of my father. I had previous acquaintance with Babla Haldar. I had a talk with Babla Haldar about the case earlier. I have altogether 5 employees under me. I cannot file my IT return. My monthly income comes to 1 lakh approximately. The trade license I filed before this court was issued on 15th February 2023. Shourab, Lokhon, Hafizul are the workers presently working under me. I maintain a diary for the purpose of keeping account of the disbursement of the salary to my workers. I get signature of my workers on such register or diary after making such payment. I can file such register diary before court. It is not a fact that I do not have any such factory in my name. Now, my lord PW1, who is the claimant, has also put this statement in his examination in chief that he used to earn 15,000. His wife used to earn 15,000 rupees. There is no cross-examination with regard to that 15,000 rupees income. The trade license, the employer's trade license is already exhibited. And kindly come to page 111, which is the salary certificate. The Aadhaar card of the employer is already exhibited. It is Exhibit 16. So, my lord, the employer comes, he states that the claimant number 1 says my wife used to earn 15,000 rupees. The employer comes, he gives his Aadhaar card, he gives his trade license, he says that I used to pay this person 15,000 rupees every month. And my lord, the only point, the difficulty is at page 31, where the income of the victim has been discussed by the tribunal. The
Page
tribunal
51.
notes, page 31.
Yes.
Kindly see what the tribunal is stating. The tribunal states that the contesting OP2, though denied the income of the deceased, but such denial is not sufficient to lead the tribunal to think otherwise by ignoring the evidence of PW2, who claimed himself to be the employer of the deceased Taposhi Shodhar, and it would be Taposhi Haldar, and admitted himself to have issued a salary certificate in the name of Taposhi Haldar. The employer, since having special knowledge about the salary of his employee, his evidence cannot be ignored simply because the contesting OP denied the claim of the petitioner about the income of the deceased. Thus, the tribunal has no other alternative left but to rely upon the testimony of PW2, Shumon Haldar, to a large extent, whose evidence otherwise could not be distracted so far as his statement pertaining to Taposhi Haldar's employment under him is concerned. Hence, notwithstanding what has been stated by the PW2 in his evidence about the monthly income of Taposhi Haldar and whatever denial has been given by the contesting OPs in this regard, this tribunal, having regard to the nature of employment of Taposhi Haldar, finds it safe and befitting to consider her notional or tentative monthly income to be not less than 10,000 at the time of her death. Well, this is judicially perverse. If I am saying that I am relying on the version of a particular witness and I am taking his version to be true, then I cannot take his version half-heartedly. Either I take notional income, 5,000, 6,000, whatever, or I take 15,000, where specially he has established his credibility, he has given the trade license, he has given his Aadhaar card. So, my lord, if I take his income and say that his evidence is justified, then 15,000 should be the monthly income, my lord. So, except monthly income, I have nothing else. One point I would like to make, my lord, on the 11th of June 2026, Honorable Supreme Court, in cases of women attending to homemakers' work, has decided for a case of 2004
Anyway,
that the income should be...
that is no. This is not a homemaker.
No, this is not a
She's
homemaker, but
engaged in
that principle has been decided that for a person with 2 children, the minimal income in 2004 should have been 30,000 rupees.
Now the question is,
Here I have given the evidence. So, my lord, there is nothing which restricts that 15,000 rupees income,
if it
especially
is-
because,
if
my
it
lord,
is-
they have not objected to that.
believable, then
exhibited
it will be
document.
accepted.
My lord, that is all, my lord. Except 15,000, I am not asking for anything else.
So others are granted.
Other things, my lord,
The
is
general damages should be reduced.
general damages, my lord. There are 2 children. If one children is a minor,
No, filial consortium only.
filial consortium.
Filial consortium means only the parents will get and the spouse will get.
Yes,
No,
yes.
spousal consortium.
Spousal consortium and the filial is the children, my lord.
Filial is not in case of the
in this case, it would be parental.
Yes,
because the mother died.
No, parental is not taken into consideration. Filial means in case of the children.
Yes. Well, I am not objecting to that. My only primary thing is about the income, my
And
lord.
the interest, that is penal
This is
interest.
6%. There should be no penal interest. 6% from the date of filing.
Yes, record and order. Learned advocate for the parties are present. Hard learned advocates. Hearing is concluded. Let this matter appear for judgment on 11/9/2026.
Deeply obliged, my lord. I'm deeply obliged, my lord.
Deeply obliged.
দুটো পেপার বুক আছে, হ্যাঁ, একটা অ্যাডিশনাল পেপার বুক একটা
Yes.
Lordship, the appellants before Lordship are the parents. The son died, son was a Mason. He used to earn rupees 3,600 per month.
That is the claimant's case.
Your Lordship, the father was examined as PW1 and the eyewitness was examined PW2.
You are challenging the quantum.
No, so dismissed.
Yes.
Now, during the examination, Your Lordship, the documents were filed. While the accident was occurred, Your Lordship, as per the seizure list, Your Lordship, the insurance certificate that was covered note was seized. So on the basis of that, Your Lordship.
Question is, you see, is the case is not dismissed with regard to the non-insurance of the vehicle. If it is not insured, it will go to the vehicle owner. That means the claimants failed to prove the case.
Without passing that order, the application was dismissed.
No, okay. Is it the case that the claimants failed to prove the case?
Your Lordship, I'm coming, Your Lordship. The cover note was filed. The insurance company did not take up any point in the WS regarding the cover note. But during the argument, Your Lordship, they disputed the cover note. Their ground that the original policy was not filed, so cover note is paid. The learned judge, what happened? The learned judge says the validity of the cover note is for 60 days. Accident occurred after 3 or 4 days of the validity of the cover note. So the claimants are not entitled to get any compensation. So decided the other points, they take up all the issues. And since the learned tribunal dismissed the claim application on the basis of cover note, so dispose of that.
So the accident took place after the validity of the cover note.
Validity of the cover note. But the insurance is for 1 year. The cover note is valid for 60 days. Now, accident occurred just after the 3 days or 4 days of the validity of the cover note. Now, after the dismissal, Your Lordship, the advocate of the court below contacted with the owner, went to the office of the insurance company, got the original policy. So they filed one review petition before the learned tribunal, stating that the original policy is here. They filed the original policy with the review.
In review petition, original policy was filed.
Filed. Now, the review petition was pending for long. So after 2 years, they withdraw the review petition and they have come before Your Lordship. 2 years, the review petition was pending. Even Your Lordship, the 147 of the Motor Vehicles, the earlier Motor Vehicles Act, 147(4). Now it is 147(5). The specific term, if the cover note is expired or if the policy is not issued, then the insurance company will inform the RTA that no policy has been issued. There is no such case before the tribunal that the policy was not issued. They have informed the RTA, nothing. You see the cover note and the policy and the review petition copy I filed with the additional paperwork. This is a cover note
petition and the original policy.
The copy of the
that original policy has to be verified. Have you verified that? So let him verify that.
You'll see the same occasion. You'll see another matter with my learned friend. We before Justice Day passed an order for verifying the policy, and they have come. Then the policy is original.
Right time that whether the policy was valid or not. Since the accident occurred in the year 2008, computer policy, insurance policy starts from 2010. Before that, manually maintained. That is why it took some time. You kindly direct my client to verify and come back after 15 days or
and submit an affidavit.
Yes.
So that.
Your Lordship, this is the earlier matter of order, Your Lordship.
Anyway, you submit that. Let's verify the facts.
Your Lordship.
Yes, record an order. এই কোথায় গেল? Learned advocates for the parties are present. Heard learned advocates. Upon hearing the learned advocates, it appears that as the dispute is with regard to the existence of insurance policy, which was not placed before the learned trial court and is sought to be relied in this appeal, the respondent insurance company should be granted an opportunity to verify the same and submit a report on the next date fixed. Thus, this matter stands adjourned till 15/9/2026. The learned advocate for the respondent insurance company is requested to obtain the verification report from the insurance company and file the same on the said date.
Deep level.
আর আছে নাকি? হ্যাঁ, জলপাইগুড়িটা দেখি। কোথায় লিস্টটা কোথায়? জলপাইগুড়ি?
Milord, item 25, Milord, sorry to trouble your Lordship. Milord, we have settled. Amount is fixed. Milord, if it appears, tomorrow anytime for 1 minute, Milord, amount is fixed. Your Lordship will, in terms of our fixation of amount, will dispose it off.
Okay, matter is settled.
Matter is settled, Milord.
Okay, let me see.
Item 25, Milord.
Okay,
Milord,
let
brief is not here today. We thought that it would not be taken up. But Milord, 30 seconds of my Lord's time in view of the settled amount, your Lordship will dispose of the appeal. If my Lord, if it permits to my Lord's time, Milord. Amount is 3,38,000 or koto? 3,38,000 is also settled, Milord. We have decided.
Okay.
Your Lordship will one line order.
Because I have to record the consent of both.
Yes. Only this.
আচ্ছা, কালকে এটা কি ওই 11টার সময় দিয়ে দেবেন তো?
1 minute of my Lord's time. 25, item 25, settled.
Item 25 টা।
এক line বলে দেবে।
Anyway, bring the records tomorrow.
Yes,
I shall see and pass necessary orders.
Lordship, extremely grateful to my Lord, Milord. 25 নম্বর, item number 25.
জি।
FMAT 7 of 2012.
তাহলে এটা হয়ে গেলে? এটা 3টের সময় তো? হ্যাঁ? তাহলে কল করে দিন এটা। আচ্ছা। দেখছি এটাই হয়ে গেল।
Bless your Lordship.
Yes, on the last occasion, I granted you liberty to obtain instructions, and if
Instructions regarding the CAN 1, Your Lordship, which the GTA has preferred, my Lord. Presently, our instruction is not to press it, my Lord. So we want
file an affidavit to that you are not willing to
please,
press that.
we shall file an affidavit to that effect.
Yes.
That the GTA doesn't want to press CAN 1, Your Lordship.
Yes, record an order.
My Lords, I'm for the petitioner in WPA 1519 of 2025, my Lords. My senior, Mr. Vikramaditya Ghosh, is on his legs before a different court, my Lords.
No, you are
So
for
if
one,
the-
item 1. Both the items.
Could be
In both
from
both the matters, this CAN 1 is filed by you.
CAN 1 is filed in Nura Super, my Lord, the second matter.
Only item 1. The CAN 1 is filed. You're not pressing.
Item number 2, that is Nura Super.
No, item 2 is Opu Chhatri.
Nura Super, then item 1.
Nura Subba is item 1. Yes, record an order.
Yes.
Learned advocates for the parties are present. It is submitted by learned advocate appearing for GTA that the said respondent is not willing to press the CAN application CAN 1 of 2024 filed in WPA 893 of 2024. Stop. In the facts and circumstances, the learned advocate is requested to in the facts and circumstances, the matter stands adjourned till 10/9/2026 at 2 p.m. The GTA authority shall file an affidavit to that effect.
And my lord, appearing on behalf of the state, my lord, I use an affidavit to the main writ petition. And also, my lord, the fact that, my lord, the ওটার নাম কি জানো ওই অথরিটিটার ব্রিফটা আসেনি আজকে হ্যাঁ
Yes, as the
NC কি জানো
as learned AG,
not here.
as learned AG prays for
NCT, the National
as
Council
learned
for
AG prays for time to file affidavit in opposition to the writ application. Such time is awarded.
Grateful to you.
The said affidavit shall be peremptorily filed on or before 1/9/2026.
1/9 is too short a time. Some more.
No, matter is pending for a long time.
No, this is the first time, my lord. In fact, my lord,
But appearing, but state government
no.
is represented.
First time the directions for affidavit.
State government did not seek any.
It's still in the motion stage. My lord, first time, my lord,
they appeared. They did not seek
my
any.
lord, it was
Anyway, on or before 3/9/2026. Reply, if any, by 8/9/2026. Let this matter appear on
Grateful, my lords.
9/2026.
And regarding, my lord, the NCT being added.
That I shall consider. Let me see your affidavit. I shall hear you and I shall consider that.
Very grateful.
Grateful, my lords.
হয়ে গেছে তো এই একটু চেম্বারে আজকে যে একটু দেখে নেবো কি কি আমার সিএবি ম্যাটার আছে আর কি আর এইটা তো নিয়ে যাচ্ছি আর কি আর রেকর্ডটা পাঠিয়ে দেবেন যেটা কালকের ওই বললাম আর কি